I'm an employment lawyer in Seattle, Washington, and I represent workers in lawsuits against their employers. And through my time doing this, I've negotiated severance payments many times. So in this video, I'm going to give you some key information about severance pay negotiations that will help you make the right decisions for your situation. So let's get started. Before we go further though, let's first talk about what severance pay actually is. Generally, severance pay comes as part of a severance agreement, and a severance agreement is a voluntary legal contract between you and your employer that outlines the terms of your separation from the company. So severance pay is generally not just a simple payment. It's a payment in exchange for you to sign an agreement. This agreement typically contains several important provisions. First, it specifies the severance payment amount, which could be a lump sum or paid out over time. Second, it almost always contains a release of claims. And third, it might include other provisions like confidentiality clauses, non-disparagement clauses, how future references will be handled, whether you will receive continued health benefits, and other provisions like that. There are important considerations for each of those provisions, but I don't have time to go over each one in this video. Instead, I'm going to focus on that earlier one that is very important to any severance agreement, which is the release of claims. You see, every severance agreement will contain a release of claims. By signing it, you're giving up your right to sue the company for anything that happened during your employment, including potential discrimination, harassment, wage violations, or wrongful termination. So when you sign a severance agreement, you're not just receiving money, you're exchanging your legal rights for that payment. Now, let's talk about whether employers are actually required to provide severance. The short answer is usually no. In most cases, employers are not legally required to offer any form of severance pay or severance agreements. There are, however, a few situations where severance might be required. First, if you have an employment contract that specifically guarantees severance pay, then yes, the employer is contractually obligated to provide it. Second, if you're in a union and covered by a collective bargaining agreement that includes severance provisions, those would apply too. And finally, in some mass layoff situations where the employer fails to provide proper advance notice under what's called the WARN Act, severance might be required as a penalty. But that's a subject for another day. I'm going to make a separate video about the WARN Act, so check back for that video if you're interested. But for most employees in America who work under at-will employment, which is almost every job, there's simply no legal requirement for employers to offer severance pay at all. So if severance pay isn't legally required in most cases, why do companies offer it? Well, the main reason is that companies offer severance when they believe there is legal liability. What I mean by that is the company is concerned that you might have a potential legal claim against them, and they're offering severance pay as a way to get you to sign that release of claims that we spoke about earlier. Remember, companies usually don't just give employees severance pay. They make you sign an agreement before they give you the money, and the agreement contains a release of claims. That release essentially means you're agreeing not to sue them for anything that happened during your employment in exchange for the severance payment. So when a company offers severance, they're essentially buying insurance against potential lawsuits. So the key factor in severance negotiations is whether you have a potential legal claim against that company. The stronger your legal claims are, the more valuable it will be for the company to get you to sign that release, which gives you leverage to negotiate a better severance payment. The strength of your legal claim is called legal liability. So let's talk about how to identify that. So how do you know if there's potential legal liability in your situation? Here are some common scenarios that might create legal liability. First, if you were terminated shortly after making a complaint about discrimination, harassment, safety violations, or wage theft, that could be illegal retaliation. Second, if you were treated differently than coworkers based on your protected characteristics, like your age, race, gender, disability, or other legally protected status, that could be discrimination. Third, if you were fired after requesting or taking medical leave, pregnancy leave, or after disclosing a disability, that could violate various employment laws too. Fourth, if you were terminated after objecting to or refusing to participate in illegal activity, that could be a claim too called wrongful termination. I've made videos about all of these legal claims and more, so I will put links to those videos in the description of this video. But these are just a few examples. The key is to look at the timing and circumstances of your termination to identify potential legal issues. But how are you supposed to value your legal claims to know what kind of severance payment to accept? Let's talk about that now. If you think you might have a potential legal claim, the next question is how to value it. Here are some key factors to consider. First, how strong is your evidence? The stronger your evidence, the more valuable your claim. For instance, do you have written evidence like an email from a manager saying something negative about your use of protected leave? Well, that would be strong evidence of a legal claim. Or are you relying on your memory of a conversation between you and your manager? Evidence like that is not as strong. Second, what damages could you potentially recover? This generally includes lost wages and sometimes emotional distress damages. Are you going to be out of work for a long time or have to take a job with lesser pay? That could equate to substantial lost wages, whereas if you already have your next job lined up and it pays as much or more, the lost wages will be minimal. And for emotional distress, was there any egregious or shocking behavior that resulted in you seeking medical help? That could equate to substantial emotional distress. Whereas if you don't have evidence of egregious behavior or negative impacts on your health, the emotional distress damages will probably be minimal. Third, what would it cost the company to defend against your claim, even if they won? Legal fees alone for a big company can be substantial. All of these factors play into the value of your potential claim and should inform your negotiation strategy. Now, what if there isn't any obvious legal liability? Should you still try to negotiate then? The short answer is no. If you don't have any potential legal claims and you just want to move on with your life, it usually makes sense to take whatever severance the company is offering you and just to move on. Remember, in most cases, the company isn't required to offer anything at all, so if they're offering something and you don't have leverage, it might be best to just accept what they're offering. Because if the company makes an offer and you push for a higher number, you are technically rejecting their offer and they do not have to make a counteroffer. So if you do not have the leverage of a possible legal claim, negotiating the company's offer can put you in a precarious position. If you do think you have potential legal claims, it usually makes sense to push for a higher severance offer. When you're negotiating based on potential legal claims, you're essentially asking the company to pay more for that release of claims. And companies will often pay more if they believe there's real risk of litigation. I've seen situations where an initial severance offer of 1 month's salary turned into 6 months' salary or more once the company understood the potential legal exposure they faced. Remember, litigation is expensive for companies, not just in terms of potential damages, but also legal fees, disruption to business operations, and time spent by key employees dealing with the lawsuit instead of running the business. Companies know this and they factor these costs into their decision-making process. Also keep in mind that your goal isn't necessarily to file a lawsuit. Your goal is to use the leverage created by potential legal claims to negotiate a better severance package. Many of my most successful cases never went to court at all. They were resolved through effective negotiation. But remember that there are risks to negotiating that you should be aware of, even if you have strong legal liability on your side. When you make a counteroffer or ask for more, you are technically rejecting their original offer. This means the company is no longer bound by their initial offer, and they could theoretically withdraw it completely. However, in practice, this rarely happens if you have a legitimate legal claim against the company. Most companies will either make a new offer or at minimum allow you to accept their original offer if negotiations stall, but there's no guarantee. So it's important to understand this risk before you start negotiating. Finally, let's talk about the benefits of having a lawyer negotiate on your behalf. First, employers tend to take lawyers more seriously because they know the lawyer understands the legal issues at play and has the ability to file a lawsuit if necessary. Second, a lawyer can objectively evaluate the strength of your potential claims and give you realistic advice about what your case might be worth. Third, a lawyer can handle the negotiation process professionally, removing the emotion from what can be a very stressful and emotional situation. And finally, in addition to negotiating the severance amount, a lawyer can help negotiate other important terms in the agreement, like references, confidentiality, and non-disparagement provisions. So there you have it. Now you know about severance pay negotiations. If you want to know more about proving employment claims, watch my video on the 5 ways to prove your employer is lying. I'll put a link to that video above, somewhere up here. And if you like this video, hit that like button and subscribe to this channel. I share videos about the laws that protect workers. The more we hold employers accountable for their wrongdoing, the more we protect other workers. That's all for me this week. See you next time.